Do you need a lawyer in your mediation? Today's episode, we're going to have a discussion about the process and steps involved in a mediation and whether or not you can do it with or without a lawyer. Welcome, Mum.
Hello, Laura. Hi, everyone.
Now, today, and it's an important disclaimer that this is just a discussion. We're not telling you what you should do with your divorce. Always check with your lawyer before making any decision. And this should be a discussion that is had with you and your lawyer in regards to your mediation.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So, Mum, it seems like a really basic question, do I need a lawyer for mediation? But there are a lot of intricacies that we're going to go into in this. And then we're going to talk about the pros and cons at the end as well of having or not having a lawyer. But before we start, in case anyone hasn't ever seen our podcast before, can you explain a little bit of your experience with mediation to start with?
Okay. Since you asked. So I've been a lawyer for more than 35 years now, and I've been a mediator and I've attended mediations for clients over the years. I've been mediating since 1994 when it wasn't even really a thing. So this conversation and this sort of discussion is just coming from a place of probably a wide experience of different sorts of mediations.
Brilliant. So Mum has been to mediation many times as the mediator and representing. So I think she's a good person to kind of listen to. And of course, all these mediations have been in Australia. So this is different in other countries, but you may be able to get some tips from this anyway. So let's start from the start, Mum. Do you need a lawyer?
Well, that depends. Is that a typical lawyer answer?
Yes.
And I think it depends really on you. It's your case, right? And you're the one with everything to lose or everything to gain, depending on how the mediation goes. So it is a kind of a personal decision. So I don't say yes and I don't say no.
Okay. And we're going to go into each step of the mediation and whether you can do that on your own or not. But can people do mediation without a lawyer?
Yes, they can.
Okay. How often do you see that?
Probably about half the time these days. Of course, if I've been the lawyer going there, they were 100% lawyer mediated support. But yes, I think about half of mediations these days go without a lawyer, particularly because of the way the court has changed the expectations in the court. You have to go to mediation before you even go to court. So that means people are often going to mediation before they even think about getting a lawyer.
Right. So, and that's important to note. There are different stages in a divorce journey when you could go into a mediation. And in Australia, you can go at any time. Anyone can go to a mediation. But when you enter the court system, then, there is court-appointed mediation. And we have some great episodes on all of those different types of mediation that you can go and listen to. Just click the link in the show notes to listen. I'll put it at the end as well. But is there a difference then between court-appointed mediation and before, like your first attempt at mediation? Do you recommend in court-appointed mediation to go without a lawyer?
Well, no, I don't recommend that ever. If you can afford it, you should, I think, take a lawyer with you to support you in a court-appointed one. But sometimes people have to save their money for potentially further down the track. Or if you know a person the other side is completely intractable and will not change their mind, then maybe you think, well, it's probably going to be wasting my money to bring a lawyer to this. So the court-appointed mediations usually use court staff to do the mediation, and they have the power, often as registrars, to make the orders there and then if you reach agreement. So it can be a little bit sudden death with the court-appointed. But the good thing about court-appointed mediation is usually by then everyone knows what their cases are, and you will have had advice about what's likely to get what orders you're likely to get, what orders you're not likely to get. Those early mediations that you do before anyone goes to court, and predictably, I think, happens in the first couple of months after separation while you're still trying to get your head around the whole thing, and it's generally about kids, then that's a kind of softer approach. And often the mediators, if they're like public mediators rather than private cost ones, they'll have a series of mediations. There'll be an intake and then they'll have maybe 3 or 4 sessions while you try to work out what to do with the children. So I think the court one's a bit more punchy and a bit shorter and a bit more lawyery legally.
Just coming from my perspective, when I went to my mediation, apart from doing it in high school and winning the Queensland Law Society Scram, I didn't know what it was going to be like, and I did not know what to expect. And if you are in that situation, of course, if you can afford it, the first thing you want to do is pay for a lawyer to come in and say, okay, you sit there, you say this, you do this. But if there is the potential to look back, and I think I kind of wish I hadn't have paid all that money to have lawyers there. I know it's good for people to know that it's an option. So let's talk about the processes of the mediation. So you go in, before you even go in, like you've just mentioned, there's an intake where you talk to the mediator. Do you do the intake with a lawyer if you have one?
No,
you don't even need a lawyer for that.
No, because the mediator is talking to both of you to assess its suitability for mediation. And so it's nothing to do with your lawyers.
Okay. All right. So that bit's don't need a lawyer for, that's fine. Then the next step before mediation is all the documents you've got to hand in. And there's a huge checklist. We've got a mediation checklist that you can get a copy of on our free resources page on thedivorcecourse.com.au. Just go up to the free resources and you can download that mediation checklist. There's a fair few documents there, Mum. Can you rattle them off the top of your head if you know them?
Oh, that's hardly fair. But look, if you go before you go to court, if you're just doing for children's matters, there's not so many documents, or the mediator may have a list of documents, but certainly that if you're going to a court-ordered mediation or it's a mediation for property, there are documents that you need to provide, sometimes at the discretion of the mediator, but at the very least, it'll be a list of assets and a outline of your case for mediation. Usually a financial statement of some sort. They'll need to be disclosure. So quite a lot of work goes in before you get a mediation.
Can people do that work without a lawyer?
I believe they can.
Have you seen people do that?
Yes. I mean, it's stressful for them.
Yeah.
But yes, the documents aren't that tricky to fill in, and the court, tries to make their language reasonable. Sometimes they get the lawyers to help them do those documents or to check them over. So yes, maybe it's a hybrid role. So kind of sometimes something done with them and then the lawyer checks it over.
So then you get to mediation day. You walk in and you're in a room. Can you explain where everyone's sitting and what happens on the day in the room?
Okay, so the pure model of mediation that you probably remember from when you were studying mediation and when I did it was that you walked into the room, there were 2 parties, the mediator sitting here, parties either side, and they just start discussing things and hope to work it out. That doesn't happen anymore because the court expects people to mediate even if there has been family violence, and because there's also an understanding of what coercive control is like and how a look from the other person can completely derail everything. So now the mediators are more likely, well, I haven't seen a non-shuttle mediation in years. So they will put you in different rooms. There may be a room that you both come into together, but if you're not feeling comfortable, or if they've got a lawyer and you haven't, or for whatever reason, you can just make the mediator give their starting talk twice, once to you, once to the other side, if it's going to be upsetting for you. And don't forget, Laura, the room, there's usually a main room where you can come together, but you don't have to, and a room for each of the parties and their support crew. But a lot of mediations now are done like this by Teams or Zoom or something. So you're not even in the same building as your mediator or your other person. You might be at your lawyer's office with your lawyer, or if you might be
when you're in those 2 different rooms, does the lawyer do the talking for you, or how does it work?
Right. So imagine you haven't got a lawyer. So you're sitting in your room, you've got a friend, you've got a cup of tea, and you're trying to keep calm, you've got all your papers. They're in the other room with their team. If you haven't got a lawyer, then you can tell the mediator what your proposal is. Usually start off with a first offer, or they may come to you with a first offer from the other side, and then they'll walk out and let you think about it and let you see if you want to make a counter offer. If you have a lawyer, the lawyer will be able to take your case or your proposals to the other person direct, and the mediator has less of a role in relaying messages. Because remember, everything that happens in a mediation is completely confidential. And so it doesn't matter if you're making concessions. You're not going to have those like, oh, well, maybe this, but it's not going to be thrown up at you when you go back to court. But also in those mediations, everything you say to the mediator in your room is confidential between you and the mediator, unless you give the mediator permission to take it over to the other side. So a lot of mediators don't like to have to sift in their mind, oh, was I allowed to say this, or is this confidential? What is the offer? So generally I'll pitch to put in writing maybe and take it over to the other side. It's tricky. So there's envoys, like it's either solicitors back and forth or maybe the mediator back and forth. And sometimes the mediator has a meeting with both lawyers to talk out offers and just see where the parties stand.
Say your ex has a lawyer. Can that lawyer come into your room to talk to you, or do they talk to the mediator who then comes to talk to you?
Yes. And if they try to come into the room, tell them to get out of the room. It's not fair. If you're feeling pressured, they shouldn't be talking to you at all.
So in that negotiation backwards and forwardsing between you talking to the mediator and you not, I mean, I guess some lawyers know subtleties and ways to negotiate that normal people don't, I guess.
Yeah, I guess. But look, I mean, how your case appears to you is like loaded with emotion and all those feelings that you have and the history. A case to a lawyer, whilst they can empathize with you, their strength is that they can look at it through a sort of a lawyer lens and see what's likely to happen. So sometimes you'll see, like I said, the mediator will get the lawyers in and go, and this is what happens. So I can tell you what happens in there, because clients don't usually know. So they'll say, all righty. So what I understand is your client wants the house and your client doesn't want the house, but doesn't want her to have the house. So is that right? Well, yes. So the lawyers might talk to each other and say, oh, well, I say the case of Davis, or I say the case of this will help my client. And they can generally at least get down to the nitty-gritty of the legal side of it between themselves without you getting stressed or your ex getting stressed. And sometimes the lawyers are good filters to take bad news back to the other side, or to dampen, like if a person's response to an offer is a swear word, for instance, and a big outrage, the other person doesn't see that, and your lawyer will, if it's you, will tamp it down and it'll just be the pure facts going back and forth.
But the mediator would damp that down anyway, wouldn't they?
Sometimes, but they've got to be very careful to not seem to be in anybody's camp. They really, of all of the people around, they have the least interest in, fair so much, because you've got to work out fair for you. They've got to work out fair. The other lawyer's got to work out fair for them, or your ex has to. And the lawyer's role, the mediator's role, is to get you to an agreement of some sort.
We get this question asked a lot. That is, will the mediator tell us what is fair? Will the mediator tell us the law so that we know that we're getting the right thing? I think some people think when they go to mediation, it's somebody sitting there giving them the instructions and trying to work as a team to get to a legal, fair result. That is not the case.
No, it's not a case. A mediator is not a judge, right? You don't have to convince the mediator. Their role is, of course, there's a triangle. There's you, your ex, and they're there, and the negotiations are going that way. And they shouldn't usually tell you what they think the law is. In fact, a lot of mediators aren't lawyers anyway. And if they are lawyers, sometimes there can be a bit what we used to call facilitative. I can still say that, facilitative mediation, where a particularly senior lawyer who's mediating might say, come on now, to the lawyers, that's not going to fly, or you're not going to leave that woman with nothing, or that man's not going to walk away. So they might kind of reality check with your lawyers. But no, really, it's not the mediator who needs to be convinced. It's the other party.
And the mediator's not going to take on the role of a judge or a lawyer and explain to you what the law is. They're literally there just to take your messages and try and get to an agreement. Okay.
Yeah.
So negotiation-wise, from what you said, you can do it without a lawyer because realistically, if you've got like anxiety about public speaking or anything like that, you're only talking to one person, and that's the mediator. If you're doing shuttle, you don't need to see your ex, you don't need to see their lawyer. So there is scope for being able to do that part. But what you are saying, on the other hand, is there are negotiation and laws that you might not know. So is there a way people can prep for that so they can go without a lawyer?
You can always go without a lawyer.
Yeah.
But to be not too much disadvantaged by not having a lawyer, I suggest people find out where they stand early on. I'll let your lawyer advise you what is likely, what they think is a reasonable thing. And armed with that, then you could go to mediation by yourself. The thing is, though, a mediation process can go 4 hours, it can go 7 hours. And some of the companies, like in the early stages, will have 5 sessions over 5 weeks. But it moves. It's like a living animal and it takes on a life of its own. So what you were very clear about when you went in may need to be looked at again in light of things as they evolve.
Okay. You know. So you've got to really be across what you're entitled to, across what the law is, and hopefully be aware that what you think you want at the start of the mediation might not be what you want closer to the end. And that gets us to the negotiation phase. Then that next bit is maybe you're locking in the agreements. Like you're going, okay, we've agreed on this. Maybe not everything, but we've agreed on some stuff. Can you do that without a lawyer?
You can, but I'd caution against that because, as I said, in a mediation, it can go for a long time and you can be kind of punch drunk by the end of it. Like so much has happened. If you don't have a lawyer there and you're emotionally exhausted and you've got the mediator presenting this for you to sign, I think you should pause and perhaps get some legal advice on that or sign it tomorrow when you're fresher. Now, I know that mediations seem to be more likely to settle if people stay in one room till they sign on the bottom line and then they leave, and that can be 7:00 at night in some places. What happens is, though, the next morning, you have what I call settler's remorse, and you're not sure that you should have signed that. And if you have signed it and it was before a registrar, for instance, the court orders may have been made that when you signed it. And so I think a little bit of if it's a good deal today, when they offer it to, it'll still be a good deal tomorrow. And I think you should wait a bit, but then there's the risk the other side will change their mind.
Yeah. And we've got an episode called, I think, 5 Things That Could Happen After Your Mediation. And we talk about the phenomenon of settler's remorse and what happens after you've agreed, what happens to the documents, all of that sort of stuff. So you can go listen to that if you're concerned about that. But you are right, Mum, that there's statistically, apparently, that is a high chance if you both sign on the day and get it sorted. We've seen a lot of stories from listeners saying they settled at mediation, they got consent orders, they both signed it, they're all ready to go. And then when it came to the paperwork to file it in the court, then their ex wouldn't sign. So, there is these little hurdles that you can come across along the way. But what you're saying is it's good if you are unrepresented at mediation to maybe just say, I just need a day to think about it, and take that breath and go and see a lawyer and double check, but be aware that could potentially undo it all and they could change their mind. Because like you said, they go home, they talk to their partner, their mums, their dads, or, their family and friends, and they go, you've been ripped off. That's outrageous. And then all of a sudden they want to change their mind. And it's hard, I think, for anyone to agree to anything because anyone who looks back in hindsight thinks they could have done better.
But they don't always get better by saying, I'm not signing it, I'm going to go to trial. And then they can look back and go, I should have accepted that deal when it was offered. So there's all those things. you touched on an interesting point, Laura, and that is your cheer squad, your people that you share information with. May all have ideas as to what would be a fair thing and what isn't a fair thing, but they're not in the room with you. They're not the ones usually paying for litigation who think I'm going to be going through this for years. You're the one who's in the moment. You're the one with the legal advice, hopefully. You're the one that's in there. So it's very hard when you go home to find support for what you've agreed to. So I often say, don't tell them what you settled on. Just tell people it's settled because they are not lawyers. They don't know everything. It's you. It's your money. It's your kids. And so just say it's settled. Be happy for me it's settled.
When it comes to the different types, if you're going in for property as opposed to if you're going in for children's matters, does that weigh differently on whether or not it's a good idea to do with or without a lawyer? Is there a difference?
I don't know. Just from a purely personal, I guess, professional experience point of view, I would say it's more important for you to have a lawyer at the property stage than at the children's stage. Simply because there are tax consequences, there need to be default provisions for property, there's possibly company issues and trusts and things, whereas with the children, you're normally just talking about how many days, and you're the expert on your kids. And a lawyer can perhaps tell you what a court's likely to do. The information's out there for you to find, and ultimately, you're thinking about what's best for the children. I think you could get advice before and maybe after a mediation, and you should be, I would think that would be safer perhaps than going with no lawyer if there's a complex property matter.
We're going to get to the pros and cons and be really basic about it, but a lot of people can't afford mediation. They can't afford a lawyer, let alone the mediation. And so a lot of people do want to do this on their own. They've got the 4 different personality types, Mum. They've got amicable, avoidant, high conflict, and manipulative and controlling. And we've done an episode on can you mediate with a narcissist? Go listen to that episode if that might be your situation. And you've discussed already saying if you think it's going to be a waste of time, spending money on a lawyer could very well be a waste of money. But then it comes to high conflict. Is it good to have a lawyer in a high conflict mediation?
It might help you. It might help the high conflict person who presumably has a high conflict with you to be more moderated. And some men will only listen to men, I think. Some women feel bullied by men, so they only listen to women. So it can just dilute the effect of the conflict and stop you and your ex falling into your old patterns of fighting. Sometimes it's really sad to see a mediation where they really are having the same argument they've had for the last 12 years that led to them separating. And each party is a little bit entrenched in high conflict. It's probably more likely you need a lawyer for that, I think.
When it comes to amicable, can you go without a lawyer?
I think so too. Look, there are all those pitfalls though for property. So there's legal questions you need to respond to. But perhaps with an amicable person, you are able to reach an agreement and then both of you have some time to go and get some advice on it and sign the document. But be careful. What we always say, Laura, is sometimes amicable is just only amicable until you say no. And then they become manipulative and controlling or are exposed as such. Yeah.
So if someone can't afford to go and see a lawyer, if someone can only afford to see the lawyer twice, what should they do to make sure they're prepped for mediation? What are those things that you would say are good?
I'd have to say our podcast isn't too bad. But there's a ton of information out there now. Years ago, there was no information about the law on the web. But now, and I think it's a good thing, it's a great thing. There's so much information you can barely absorb it all. But educate yourself. Look at the sections of the Act. The court has those sections highlighted. So you have to look into the Family Law Act, look for the sections relating to children, see if you can distill it down to something basic and have that in your back pocket, so to speak.
And do our course. You could do our course.
absolutely, you could do our course.
Yeah.
In fact, those people, following our own comfort here, but they often do mediation without lawyers, don't they? And get an outcome. But
Yeah.
we always say go and see a lawyer anyway afterwards.
Yes.
Yeah. And sometimes lawyers, I know I did this through the years. I'd say, look, it's too dear for me to come with you all, but I'll be in the office. You can ring me up and send me a copy of the orders and I'll give you some advice at the end of the day. So you may find a lawyer who's prepared to do that, and they already know your case.
Okay.
Yeah.
People ask, do I bring a barrister? My lawyer wants to bring a barrister to my
No.
mediation. Do I bring a barrister?
I think I'd see a barrister only for big money cases. And when I say big money, I mean with complex company structures and trusts. That actually there might not be much money at the end of the day, but there might be a lot of structures. So it might have a barrister. I'd wonder why your lawyer isn't confident enough, though, to do if it's more your garden variety, house, car, credit card, kids, like why your lawyer feels they need a barrister for that. So get them to tell you why. Get them to tell you why in a letter, I reckon.
Yeah.
And then you might be able to say to your lawyer, and again, we're just discussing it, but you could say, if it turns out that the barrister's not really going to add much, to say, look, no, I don't want a barrister. I want you on your own. Are you prepared to do it on your own? And then ask them to tell you why they're not. Because if they're afraid to, then maybe you should be afraid to go there without a barrister too. So find out what it is that they're thinking.
Let's go into the different types of pros and cons. So the first con is cost. Tell us a bit about that.
Well, if you're going to a private mediator, you've paid half the mediator's fee each. You pay your lawyer by the hour for how long they're there, right? So if your lawyer's $500 an hour and you're there for 4 hours, say that's $2,000. Plus there's the cost of preparation for the lawyer as well. So costs is a biggie. And if they bring a barrister, the barrister might be a couple of $1,000s on top of that. And so it can be very expensive very quickly.
So you can, one of the cons is you save money. And Mum always says that if you can look top down at your case and where it's going and be realistic, is there a chance you're going to settle or is there no chance you're going to settle? And if you've got only a certain amount of money, is it better to save it if you think you're heading to a trial? So you've got to weigh all of that up. You really have to look at your expenses, look at how much you're willing to spend, look at how much you're willing to learn and whether or not you think this is going to be like the divorce personality type. Is this going to work? Is this worth it to spend for this? Because spending, like you just said, Mum, spending like $10,000 and getting zilch as an outcome, because it's not like anything can be presented to court to say, oh, he said this in mediation. It's all confidential. So you could literally just pay $10,000 to be forced to sit in a room and negotiate all day with no outcome.
And also too, the lawyer who has to be there isn't every minute of those 4 hours usually giving you legal advice.
That's true.
They're sitting there going, hum-ti-dum-ti-dum, we're waiting on an offer from the other side. Do you know, it's very poor use, I think, of resources sometimes. Sure, they're there to advise if a different offer comes in and to help you formulate an offer. But a lot of it is just waiting and you're paying a lot of money for that. Mind you, Laura, if you pay the money and you get an outcome, that's the cheapest trial you'll ever have.
True. Then it comes to the next con is that they might minimize things. Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today. True. Then it comes to the next con is that they might minimize things.
Yeah.
Focus and not fight hard enough. So what were you meaning by this?
Yeah.
You're going to get in trouble.
No, I'm not. Look, I reckon, look at the finger. I reckon
Mum's
I
way.
reckon that not every lawyer takes on board the impact of things on their client. I think there's a risk that after 10 years of doing these things, they're like, oh, yeah, dismissive and bundle it up. They might even have in their head a number, and they may not properly present your case, even though properly presenting it might affect the outcome. So I've had it a number of times. I've heard of this, people minimizing Kennan's case. Now, Kennan's case, I talk about it on the Patreon, a case from years ago. And the people there, the judges said, if there's abuse and the impact makes your contributions harder, you should get a higher percentage of that. And then for about 10 or so years, the court backpedaled from that. But now they're not. So the law's turned around, and some lawyers who aren't really up to date might not realise that now you can make that argument about family violence on a property settlement case. I can tell you people are still hearing from their lawyers that domestic violence doesn't count in property matters, for instance. It's like you've got to educate yourself. Even if you've got a lawyer, I think you need to educate yourself so that you can say to them, do you know what? No, this matters. And I heard on the podcast that the Property Law Act is going to be changing.
So if you want to learn more about that and that phenomenon of the lawyers just minimising and not wanting to go down that path, we've called it legal gatekeeping. And we talk about the potential new changes that are coming. New changes, because we've been talking about the other ones for so long. They're through. Now these are the new ones. So go and listen to that. But you're right. I do feel like some people come out of mediation worrying that they've spent all this money on a lawyer, and the lawyer just kind of cookie cutter, just kind of cruised through and just treated it just like everybody else's case, which is fine because they've got a lot of cases. But when it's your case, you're like, but it's my case.
You don't feel heard. You often will come out. And they have this thing that started in the US with mental health, and they call it therapeutic jurisprudence. And they found that people with mental health issues, if they go before the tribunal, if they help to formulate their case to put forward and agree on consequences, there was greater compliance and more satisfaction. In family law, the survey that I sat on a board for a while in the family court, where people said, even though they got a good outcome, they didn't feel heard and they really were still upset. So you need someone to take your issues seriously. And if you've got a lawyer who's not, ask them to put in writing why. If you're paying a lawyer, ask them to put in writing why your case doesn't matter that way. But I think if you don't feel heard, you're not going to feel happy, and you'll look back years to come go, oh, I wish I'd pushed that. So do you do yourself a favour?
Now, this one's really important, and this happens to a lot of people. A lot of people write in and say this. They felt pressured. So this is the other con. They might feel pressure. And I do hear a lot of people saying, oh, but my lawyer just said it was the best thing. I needed to settle. Just, sign here, just get it over with. And they felt all this pressure. So can you explain that and what people need to be aware of?
Well, yes, I think it's two sides to that pressure thing. One is you may need someone to lay it on the line for you and tell you it's a good deal, sign it and move on, even though you don't want to hear it. Someone's got to speak the hard truth to you, okay? But then the other side of it is where you don't feel heard. They don't bring you along to saying this is a good deal. And again, I think the magic thing for anyone in this situation is to say, why is it a good deal? Tell me some cases. Do the percentages. Why is it a good deal for me? I don't think that helps you to understand it, because I think you can say to your lawyers, honestly, if it's 7:00 at night and you guys haven't eaten, and you can say, I feel pressured, and any good lawyer should back a bit. And they may just want you to sign it so that it's good for you, so that the other party can't renege tomorrow and you're safe. But they have to bring you along with it. They have to say to you the reasons why. You're not an idiot. and they need to show you why it's a good idea. But look, not every lawyer pressuring you is a bad thing. They may be right. Okay. But you shouldn't feel pressured. So there should be some more advice given so that you can say, I'm disappointed, but I get it.
Yeah. Now let's go on to the 3 pros.
Okay. The good things, Rose. The good things, Laura.
So the good things is that lawyers know the law.
They do.
Number 1.
Yeah. hope.
You hope. And get your head around the law, listen to the podcast, do the course, do whatever you can to know the law, because lawyers know the law. That's what it comes down to.
That's right.
The next one is that they'll present your case in a way that perhaps the other lawyer or the other side will understand.
Yes. And especially if the other side's got a barrister or a lawyer there, solicitor there, they can have the head-to-heads and talk about the different cases and what are the prospects and what it's going to cost to go. Like, they can have quite a hard-nosed discussion hopefully without emotion, but
in another room, away from
another room. Yeah, away from you, and sometimes with the mediator.
Right.
And so I've seen mediators who lean back and go, so tell me, Mr. Such and Such, what makes you think your client will get 75% of the property pool? Like, there's real reality checking can take place if you've got a lawyer, but they're never going to say that to you.
Right. Okay. And then support.
Yep. And they are there for support. If you've got someone you trust and they've got your case covered and they've got your files there and they know what to say and what to do, then you're just there to make the important decisions and give the important advice. But you're not having to scrabble through paperwork, trying to work out the maths. And seriously, it's your life. So you're going to be a little bit stressed and overwhelmed. And there's something nice about having someone you trust with you.
Now, I'm going to say something controversial, Mum.
I could see your face. I knew you were going to do that.
I think one of the pros to having a lawyer is you get support. Just bring a friend. They're free. Like, why pay a lawyer when you can just have your mate come? Like, seriously.
Well, yes. But your mate might be like you. Like, if they're your really good friend, they've probably got I've got an attitude, I've got an opinion. So they're no better than you. They're in the hall with you, okay? They've suffered all of the late night phone calls and all the dramas. So they're in it. They can't be objective. So what you've got in a lawyer is support and objectivity. How's that?
Nah.
You don't think so?
But lawyers aren't trained to be psychological supporters. I don't, nah. But okay, so realistically, Mum, my opinion, if it's worth anything, which it isn't really, but I do think people can do mediations on their own. I do think so. If you
tell me that.
Yeah, well, I do. I think if you are willing to understand what your situation is, in a way, it even forces you to pay attention to what your situation is, to look at the figures, to look at the facts, and to think, okay, this is my situation, this is it. Because I do feel like some people just turn up to a mediation, waltz in, sit down, and think it's just all going to happen around them, when it's really up to you and your mind to come to this decision. And you're not going to come to this decision unless you've looked at the facts and you understand the law. And I think the early mediations and that kind of stuff is better without a lawyer. I do, as long as you've seen one and you understand the law. I think that's the pro of a lawyer. They know the law. That's it. I think we are all smart enough to sit in a room and have some grown-up come in and say they want to do this. And you can say, okay, or no. So I just want to make sure that people who are listening are not paying for a lawyer just because they're scared, like in a court setting, that they don't know what to say or do, because there is no official say or do apart from the documents you have to hand in before you turn up to a mediation. But you can do this negotiating at a mediation yourself if you're brave enough and you're willing to learn. And no offense to you, Mum, but I do think people are in danger of throwing all their money away at the beginning and then being stuck, like our listener wrote in and said she was there with 3 other ladies and they were all self-representing in a trial. So Really have a think. And if you're listening to this now doing something like cleaning or driving or whatever, pull over, stop, just have a think right now. What is the likelihood of you succeeding in this mediation? And would you succeed or be able to negotiate better if you fully understood it, your situation, and really get your head around it and be realistic so that you can budget for it, I guess. So,
Yeah.
Mum, if someone can't afford to take a lawyer to a mediation, your options are, like you said, go and see them before, come up with some strategies, see them after, before you sign something, call them. You can call them. Are there anything else they could do?
I think just educating themselves prior to that. But yeah, I hear what you're saying, Laura. I hear what you're saying. And it is easy to waste all your money early on because no one ever asks the question, do I really need a lawyer to do a family court trial?
No one asks that question.
No one asks that question.
Everyone would want one. Like, of course you want one.
But in a mediation, remember the pure models of mediation were really appealing to hearts and minds. They weren't kind of transactional. But if they are, like if they offer $3 and you offer $5 and they offer $4 and it's all sorted, we can all do that.
Yeah.
We can all do that. So yeah, I take what you say on board, Laura.
Just be careful and really talk to if you have a lawyer, ask them, can I do this myself? Why do you think I can't do this by myself? What things can I do to make up for that?
Well, and I think in all of the years of mediation, right, I think that I've never had many people who go, this is going to be a doddle, we're going to reach agreement this time. They all pretty well go, we're never going to reach agreement, because if they were going to easily, they probably would have done it in their early text messages or early letters. So a lot of people go in and say, this isn't going to work at all. And sometimes they're pleasantly surprised that it does work. But you're right, you should know that just spending a lot of money on barristers and the mediator and the lawyers doesn't necessarily mean you're going to get an outcome. And if you don't have a settlement, you're just going to be even more disappointed afterward. I think the key is, how much of your legal budget are you going to spend on this chance? Because if it works, that's wonderful and you've saved a fortune. But if it doesn't work, you've really thrown money away.
Don't we all wish we had a crystal ball or a time machine so you could go and figure that out and come back and go, oh, I'm not going to spend money on a lawyer. And that's why everybody's situation is different. Your divorce personality type, your budget, your lawyer, your situation all needs to come into account, and your mental state. And all of those things combined needs to weigh up your decision on whether you need a lawyer. But you can do it without a lawyer. People do it without a lawyer. It's just a question of whether you should or you want to or you can afford it.
I think you've summed that up beautifully.
Yeah. Cool. Thank you, Mum, for your time. And if anybody else is interested in any of our other mediation episodes, you can go and listen to them. I will list them below. But we might just shout out to someone who's given us a review.
Oh, lovely.
So if anybody gives a review on Spotify or Apple or YouTube, for YouTube, you can just put it in the comments.
But we're desperately trying to get our YouTube numbers up. If you like our podcast, can you go in and just like us?
Help us get to 1,000 subscribers. Yes. That's all we want to get to.
It's modest enough ambition.
We just want to get to 1,000 subscribers.
Because the more people that can hear podcasts, hopefully, they don't feel so alone.
And all this information is free and available to anyone going through this hell situation. It's not fun for anyone. No one signs up for this kind of stuff. So if you comment or give us a rating or a review on any of those platforms, we go through and we choose one each month. And that person gets a free phone call with Mum. So today is at Purple Pixie 77. You can send us an email at thedivorcecourspodcast@gmail.com. And she writes, ladies, you're amazing. Thank you for sharing this type of education for Australian people who can relate based on Australian legal system. I've subscribed. She also did write another comment on another one. I can't find it right now, but she was saying, can you get someone to help you with your marketing so more people could find out about you, because she wished she found us earlier. So
yeah, true.
happy for you guys to write as many comments as you like, and we will go through and we'll check at the end of the month and choose another one. But thank you, Mum, for your time. Good luck to anybody going through mediation. We wish you all the best of luck, and we'll see you all back next week.
Bye,
Thanks,
everyone.
Mum.
Bye, Laura.
If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording